Mr. President, I rise to speak about the nomination of Judge Neil M. Gorsuch to be an Associate Justice on the United States Supreme Court. Confirmation of anyone appointed to the federal judiciary is a big deal. Confirmation of someone appointed to serve on the Supreme Court of the United States is an exceptionally weighty matter, and I therefore approach this with the seriousness that it deserves. I approach this as one who has argued in front of Judge Gorsuch. I found as a lawyer that he's an exceptional judge, an unusual judge, a judge who comes to argument with an unusual degree of preparation. Having read all the briefs and apparently all of the cases and all of the statutes cited in the briefs. There are some judges who, at oral argument, are constantly asking questions, but they're not necessarily questions that need to be asked. Perhaps some judges want to hear the sound of their own voices. That's, of course, something that would never happen here in the United States Senate, but it happens sometimes with other people. There are other judges who might be quiet throughout an argument. And then there's a unique category of judge. A judge who doesn't necessarily speak constantly, but a judge who listens attentively and then pounces at the moment when he or she sees the pivotal moment in the case arising. The late Justice Oliver Wendell Holmes, Jr. used to say that there is a point of contact in every case. And when asked, he pointed out that the point of contact in any case is the place where the boy got his finger caught in the machinery. I learned that quote when I was in law school. I've never entirely understood what it means, but it reminds me of the fact that in every case, there is a pivotal fact and a pivotal aspect of the law, which, when properly understood, can help lead the judge, can help lead the court to a proper disposition of the legal question at hand. Judge Gorsuch is one of those rare judges who is able to seize upon the point of contact in any case. He does so with seeming effortlessness, and yet I know he does it in a way that requires a lot of effort, because these things don't just come naturally. They come only as a result of faithful study of the law, of faithful attention to detail in every case, reading every brief in every case. Judge Gorsuch does this in part because he was well trained. When we look at his background, we can see that excellence has always been something that we've been able to see from him. He graduated with honors from Harvard Law School, and he received a doctorate in jurisprudence from Oxford. He clerked for three brilliant and very well-respected jurists: Judge David Sentel of the U.S. Court of Appeals for the D.C. Circuit, and Justice Byron White, as well as Justice Anthony Kennedy on the U.S. Supreme Court. You could not ask for a better legal education or for a stronger record of accomplishment in a young lawyer. After his clerkships, Judge Gorsuch entered into private practice, where he was a trial attorney for 10 years. In 2005, he joined the U.S. Department of Justice as Principal Deputy Attorney General, and he became a judge on the 10th Circuit in 2006, where he has served for the last decade. Judge Gorsuch has what I would consider, and I think what most would acknowledge, is the correct approach to the law. He is a judge's judge, both literally and figuratively. Literally, because he sits on the U.S. Court of Appeals for the 10th Circuit. He literally judges the rulings of other judges. It's his job to decide whether other judges have done the right thing. And he's a judge's judge figuratively, in the sense that he has the characteristics that all judges aspire to, or at least should. He decides cases based on what the law says, and not on the basis of what a particular judge might wish the law said. I particularly enjoyed last night, while listening to Judge Gorsuch speak at the White House, his reference to what he considers an important telltale sign of a good judge or a bad judge. He said, "A judge who likes every outcome he reaches is very likely a bad judge, stretching for results he prefers rather than those the law demands." So a bad judge is one who necessarily likes all the results he reaches, and it naturally follows that a good judge will from time to time necessarily disagree with some of the judge's own rulings. In other words, the outcome of the case doesn't necessarily match up with the outcome that the good judge, would prefer, were the judge an all-powerful ruler who had the power not only to interpret the law, but also make it, establishing rules, embodying policies that would govern in all cases. This is the essence of the conservative legal movement, the judicial conservative movement, you might say, in which Justice Scalia was so influential, which is why it's so fitting that Judge Gorsuch has been named to replace Justice Scalia. Judges do not have a roving commission to simply address all of the evils that plague society. They don't have a roving commission to decide big policy questions of the sort that we debate in this chamber every day. The judge's role, rather, is to apply the facts to the case at hand. And in the case of the Supreme Court, to provide guidance to lower courts so that they can resolve difficult and consequential questions of law. Judge Gorsuch understands the difference between being a judge and being a legislator, and that's very much reflected in his work on the bench. So when I had the privilege of practicing law and appearing in front of Judge Gorsuch, I was able to be the beneficiary of his skill as a judge and of his commitment to the rule of law. And over the last few days, I've had the privilege of reading many of his opinions. I've spent hours upon hours poring through his opinions, knowing that he might well be named to the Supreme Court. Knowing that he was one of the potential nominees made me want to learn more about him than I already knew. And I have to say, every single opinion I read, without exception, was impeccable to an unusual degree. They're methodical, they're careful, they're studious. They reflect a degree of academic and professional craftsmanship rarely seen. He treats the parties appearing before him with dignity and respect. He takes their arguments seriously, and he respectfully explains their arguments as he addresses them. I know from my time in the practice of law that no one likes to lose a case, but I doubt any litigant has read a Judge Gorsuch opinion and felt like he failed to understand their position or that he failed to take their views seriously with the credibility and dignity they deserved. This is a crucial, yet sadly often underrated factor when reviewing the work of any judge. But most of all, Mr. President, his opinions are just brilliant. They're digestible to lawyers and non-lawyers alike. And this is crucial because the judiciary belongs to everyone in this country, not just to attorneys. Judge Gorsuch's opinions are memorably written without being snarky, and he scatters his opinions with literary and philosophical references that serve at once to highlight the legal points that he's making, while also just making the opinion much more interesting. As someone who has read more than my fair share of judicial opinions, I can tell you that Judge Gorsuch's opinions are among the very best I've ever read. And I don't just mean a few of them. I mean every single one of them that I've read, which is a lot of them. They are very, very good. In fact, they are Supreme Court caliber. Judge Gorsuch has written hundreds of opinions, but there are two recently decided cases that I wanted to highlight. He's a critic of an obscure but very significant legal rule known as the Chevron doctrine. When the Supreme Court decided the Chevron case back in 1984, the justices may not have thought that they were deciding a big case. They might not have realized the extent to which this decision in Chevron versus NRDC, the extent to which that case would have such a profound impact on the federal judiciary and on the state of the law in the United States of America. But Chevron is, in fact, one of the most important Supreme Court cases that most of us have never heard of. It says that the courts must defer to an agency interpretation of a statute if the statute is ambiguous. The problem with Chevron, as Judge Gorsuch has pointed out, is that it tends to divest the courts of their obligation to say what the law is, as Chief Justice John Marshall wrote in Marbury versus Madison. It has led to a system in which executive agencies not only make and enforce the law, but also interpret the law, arrogating to themselves, in effect, some aspects of the powers allocated to all three branches of the federal government. This, Mr. President, is a violation of the doctrine of separation of powers. One of the most important protections in the Constitution, one of the two fundamental structural protections in the Constitution, as important as any other provision in our founding document. Worse, doctrines that have developed in response to Chevron allow agencies to stake out a legal position, lose in court, and stake out a new legal position that reaches the same outcome. As Judge Gorsuch points out, that creates fair notice and equal protection problems. Now, there are two additional points to make about Chevron. First, in the coming days, you'll undoubtedly hear some of my colleagues complain that getting rid of Chevron will somehow make the air less clean, our food less safe, our financial system more unstable, and cause a whole lot of other problems. But as Judge Gorsuch has written, quote, "We managed to live with the administrative state before Chevron. We could do it again. Put simply, it seems to me that in a world without Chevron, very little would change, except perhaps the most important things," close quote. Second, it's important to note here that the Chevron doctrine is not a particularly ideological one. Indeed, in the 1980s, Chevron primarily assisted the Reagan administration's deregulation efforts. And junking the doctrine today would constrain the Trump administration's use of regulations. So eliminating the doctrine would affect equally Republican and Democratic policy goals. In any event, I'm sure, based on his background and on his record, Judge Gorsuch's critique of the doctrine is not about politics. It's about first principles. Chevron, at the end of the day, is neither Republican nor Democratic. It's neither liberal nor conservative. It's simply wrong. In another notable case, Judge Gorsuch was the lone dissenter in a case in which an 11-year-old student was arrested for generating fake burps in class. As heinous a crime as some might perceive this to be, it's not ordinarily the kind of thing that results in calling the police. Judge Gorsuch would have concluded that clearly established law prevented the arrest and that the child's parents should prevail in a lawsuit against the school officials who decided to call the police in response to this childish act in class. This is not uncommon for Judge Gorsuch, who has voted to provide qualified immunity in several cases and has voted in many cases for the underdog, for someone who might otherwise not have had a chance in court, but for the willingness of one very brave and astute and diligent judge to study the law and the facts of that case aggressively so as to make sure that justice was accorded to the parties. There are other important areas of the law where Judge Gorsuch has made an important contribution during his time on the U.S. Court of Appeals for the 10th Circuit, and I'll be talking about some of those at length in the days and weeks to come. He's been a staunch advocate for the First Amendment. He's read criminal statutes to constrain the government's power where appropriate, and has voted in several cases to withhold qualified immunity. All of these are important, and I look forward to discussing them with my colleagues. Before I close, I want to talk a bit about the confirmation process. In 2006, Judge Gorsuch's nomination to the 10th Circuit was so uncontroversial that it lasted 26 minutes. Just 26 minutes. It's less time than a Brady Bunch episode. And he was confirmed on a voice vote. Among other notable members of the Senate, the day that Judge Gorsuch was confirmed, Minority Leader Schumer, Ranking Member of the Judiciary Committee Feinstein, Senator Durbin, and Senator Leahy. Already, prominent liberal lawyers are praising his nomination. Neil Katyal, who served as acting Solicitor General under President Obama, has a New York Times op-ed in which he urges liberals to support Judge Gorsuch. Katyal writes, quote, "I, for one, wish it were a Democrat choosing the next justice, but since that is not to be, one basic criterion should be paramount. Is the nominee someone who will stand up for the rule of law and say no to a president or Congress that strays beyond the Constitution and laws? I have no doubt that if confirmed, Judge Gorsuch would help restore confidence in the rule of law. His years on the bench reveal a commitment to judicial independence, a record that should give the American people confidence that he will not compromise principle to favor the president who appointed him." Close quote. Judge Gorsuch is exactly the type of judge who should be confirmed, who should be allowed to serve on the Supreme Court of the United States. This vacancy was a central issue in the 2016 election. The people have now spoken, and I plan to honor the results of this election by working as hard as I can to see Judge Neil Gorsuch confirmed to the Supreme Court of the United States. Thank you, Mr. President.